Can a divorce decree be modified? Have you ever wondered if a divorce decree can be changed after it has been finalized? This is a common question for many people navigating the complexities of divorce and separation. The answer is yes, a divorce decree can indeed be modified, but there are specific conditions that must be met. First, let's talk about the areas that are eligible for modification. Typically, changes can be made in three main areas: child custody arrangements, child support payments, and spousal support, also known as alimony. These aspects are often subject to review because they directly impact the welfare of children and the financial situations of both parties. On the other hand, property division is generally considered final and cannot be altered once the decree is issued. Now, what are the grounds for modifying a divorce decree? To initiate a change, there usually needs to be a significant change in circumstances since the original order was put in place. For example, if one party experiences a substantial change in income, such as losing a job or starting a new job with different pay, this could be grounds for modification. Other reasons might include relocating, changes in the child's needs, or even the remarriage of a spouse, which could affect spousal support obligations. So, how does one go about modifying a divorce decree? The party seeking the change must file a formal motion with the court. This process involves notifying the other party and presenting evidence that supports the request for modification. Sometimes, this may lead to a court hearing where a judge will evaluate the situation. The judge will decide whether to grant the modification based on what is in the best interests of the child or what is fair to the parties involved. In some cases, former spouses can agree to modify certain terms of the divorce decree without any conflict. If both parties consent to the changes, they can jointly petition the court to amend the order. This approach is often simpler and less adversarial than going through litigation. It is also wise to seek legal assistance when considering a modification. Navigating the legal procedures can be complex, and having an attorney who understands family law can help ensure that the process goes smoothly. In summary, while a divorce decree can be modified, it is essential to understand the specific areas where changes can occur and the necessary steps to initiate the process. Whether due to a change in circumstances or mutual agreement, modifications can help keep the court's orders relevant to the current situation of the parties involved, especially when children are part of the equation.